My plan is to hide, to avoid, but if I get busted, if I get captured, I'm not going to do a Rambo, I'm going to do a Gandhi. If I get captured, I'm not going to do a Rambo, I'm going to do a Gandhi. If I get captured, I'm not going to do a Rambo, I'm going to do a Gandhi.
Peace and blessings, everybody. It's Monday, October the 28th, the year 2019, and I have in front of me the Michael Filipovic's response to the government's resentencing memorandum. For those of you that have been keeping up, Schaeffer Cox will be resentenced in 7 days. We originally read the resentencing memorandum by Michael Filipovic. We read then the Department of Justice, United States government resentencing memorandum where they're asking for 26 years. And now we have a response to the government's resentencing memorandum that just came out tonight. So it's about 18 pages long. I'm going to read the first page. Aaron's going to read the second page. We'll probably go back and forth, and we're going to spell each other out. That's the benefit of having a wonderful wife, which I enjoy every day, and I'm very blessed. Okay, here we go.
Federal Defender Michael Filipovic and Assistant Federal Defender Ann Wake.
Wait. The thing's not close to your mouth. I was going to read the first page.
Let me just read.
You want to read?
Yeah. It's his birthday today.
You got to read starting right there and just kind of tell what it is.
In the United States District Court for the District of Alaska, United States of America, plaintiff versus Francis Schaeffer Cox. That's an interesting plaintiff. Okay. Federal Defender Michael Filipovic and Assistant Federal Defender Ann Wagner, counsel for Francis Schaeffer Cox, respectfully submit this response to the government's resentencing memorandum. The defendant's resentencing memorandum was filed on October 7th and a corrected version filed on October 11th, docket 740-743. The government filed its resentencing memorandum on October 21st, which included a response to the defense memorandum, docket 748. What follows is a response to specific points made in the government's memo, along with support letters for Mr. Cox and additional materials for the court's consideration, exhibits 42 to 47. Number 1. Introduction and the government's reliance on 241. In support of its argument that a 26-year prison term is necessary to reflect the seriousness of the offense, the government relies not on the basis upon which the Ninth Circuit upheld the conspiracy to murder conviction, but instead on the so-called 241 discussions, a theory which the government by the end of trial effectively abandoned as a basis for liability by characterizing it in closing as a round-table discussion and a debate rather than an agreement. Docket 647 at 87. But now it seeks to elevate this round-table discussion and debate to the most dangerous and threatening part of this case, one that posed the greatest risk for harm to others, in considering the government's shift from the limited Stalinist martial law theory on which the Ninth Circuit upheld the conviction. The court must first determine whether that theory can even be considered as part of the sentencing analysis under the nature and circumstances of the offense of conviction under 18 U.S.C. 3553A, or whether it should only be considered generally in assessing Mr. Cox's history and characteristics under 3553A. It should not be the driving force in determining the seriousness of the offense and what an appropriate sentence should be where the conviction is not based on that government theory and where the government itself has characterized that theory as merely a roundtable discussion or debate. Number 2. Guideline implications of the government's reliance on 241. The government characterizes the defense and the Ninth Circuit's focus on the Stalinist martial law theory as vacacious, then appears to abandon that theory for sentencing and instead puts its sentencing focus on 241. This approach has significant implications for the guideline calculations. It effectively removes the sixth-level official victim adjustment and reduces Mr. Cox's guideline offense level from 41 to 35. With a criminal history category 2, his range would be 188 months to 235 months, and factoring in the overstated criminal history reduction suggested by the court at the first sentencing, the range would be further reduced to 168 months to 210 months from the life range which the court employed as the starting point at the first sentencing, docket 605 at 19. As argued in our resentencing memorandum, the level 6 victim adjustment under USSG 3AI 1-2B requires that the victim be a federal government officer or employee and that the offense of conviction be motivated by such status. Docket 743 at 46 to 48. The PSR identified the 3 DHS employees whose names were found buried in a legal pad and the name of a U.S. Marshal in Anderson's field manual as the, quote, victims, justifying this adjustment. We challenged that adjustment because the contingency of martial law was not motivated by the federal status of these 3 DHS employees. Rather, they would be targeted if and only if they were carrying out Stalinist martial law. The U.S. Marshal was not the subject of any agreement because Mr. Anderson came across his name independently, never told Cox about it, and never added it to the database. See docket 629 at 171 190-91. Based on the government's shift to the 241 theory, a theory not recognized by the Ninth Circuit as supporting this conviction, Mr. Cox also objects to this adjustment because there are no federal officers. No federal officers. Where was I?
Right there.
Or employees who would be the subject of 241. The government argues that 241 could possibly, quote, be triggered by the arrest of Cox, Barney, Vernon, or family members, or the removal of his son by OCS, and that Cox's arrest on his misdemeanor failure to appear in state court arrest warrant was imminent, quote, docket 748 at 4/19/28. As set forth below, the government exaggerates the evidence supporting these claims, but taking the claim at face value requires the court to find that there is no federal officer or employee who is a victim under this theory. The 3 DHS individuals and the U.S. Marshal identified in the revised PSR do not fall within the 241 scenario, as set forth by the government. If Cox were arrested on the misdemeanor warrant, that arrest would be by local officials, not federal agents. OCS is an Alaska state agency, and an employee of that agency would not qualify for purposes of this adjustment. Moreover, a generalized possibility that some unidentified or unknown federal agent might participate in such an arrest and trigger 241 against some other unidentified federal agents would not be sufficient because the guideline only applies when specified individuals are victims of the offense and does not apply when the only victim is an organization, agency, or the government. Thus, the government's reliance on 241 as opposed to the database is an additional basis for rejecting that sixth level adjustment. Number 3. The government's new assertions about 241 are belied by the record, its own statements, and the evidence. Belied. If the court considers 241 a Section 3553A factor under either the nature or circumstance of the offense or as a history and characteristic of the defendant, a close review of the facts is important. The government embellishes, overstates, and makes incorrect factual assertions as the foundation for its core claim relating to dangerousness. It does so by making broad factual assertions without citation to the underlying factual record. And when it does cite to the record, it cites its own Ninth Circuit brief, which in large part suffers from that same flaw. In order to properly assess how much danger, if any, 241 posed, and thus how much sentencing weight it should be given, the court should begin its analysis of the facts with the government's assessment of 241 as recorded in email traffic before the arrests of the defendants and statements it made in closing arguments referring to 241 as no more than a roundtable discussion and debate. In closing, the government made no effort to argue that 241 amounted to an agreement or plan at all, much less a conspiracy to murder federal employees. But now it argues that 241 was a firm plan to be implemented upon the arrest of Mr. Cox or others. Docket 748-4-1322. The government's trial assessment was much closer to the truth. The government first claims that there exist recorded statements made by Cox establishing his intent to murder. If one of his men were captured by law enforcement, he was taken into custody, or any member of his family taken into custody. ID at 3, the record does not support this claim. It goes on to argue again without citation to the record. And then this is a little paragraph. It says, in the brief, the defense fails to mention the clear, present, and real possibility that Cox was clear on the 241. It would occur upon his arrest, an arrest of a militia member or a member of his family. The reality was and is Cox's arrest was imminent, and if he was arrested, his loyal Lieutenant Barney, Sergeant Vernon, and possibly others were ready to take up his cause. Numbers of militia members were irrelevant. All it would have taken was one of these men to implement Cox's plan upon his arrest. ID at 4. This goes back to regular whatever paragraphs. Number 13, I guess, line. As the transcripts recording the 241 discussions make clear, the 241 discussion never amounted to an agreement at all. See generally docket 743-2 at 13-57 X2, except perhaps the definitive plan for Monday, the day Cox intended not to appear for a court hearing, trying to lay low Monday and avoid, if they're coming out with bench warrant, avoid it and try to hit them with paperwork every way I can, unquote. ID at 49-50, EX is Exhibit 2 at 37-38. In the event that Cox were arrested or killed, he suggested on February 12, 2011, the thing that you probably could get everybody to go in on, I agree to, is just raise hell by having picketing and just like, well, not quite a riot, but almost, and on the radio and TV and sit-ins and just every kind of, peaceful protest and just get everybody's panties in a wad. ID at 51-57. Exhibit 2 at 38-39. After hearing these conversations on February 13th, Mr. Scrocky wrote to his supervisor and case agent that Cox is full of it. I have to say, he's a legend in his own mind. Docket 743-3 at 48, Exhibit 16 at 2. Far from worrying that the trigger for 241 was imminent, as the government is now asserting, Mr. Scrocky told his team that Cox's plan was, small paragraph, to avoid law enforcement, and if they have a warrant, he wants to respond back with more paperwork. If he gets arrested or killed, he said, start training for 241. In the meantime, we raise hell by rioting, sit-ins, radio, TV, and peaceful, let me repeat that, peaceful protests. We should let him do this. It will buy us time on the weapons investigation and will diffuse his followers. Big paragraph again. ID, emphasis added. Mr. Scrocky continued, I've looked at the statutes again and nothing fits, and ultimately concluded, one guy's wife called him at the end of the meeting and gave him the, do you know what time it is thing? And he beat it. It was, I don't know if this sums this group up, but it's not the stuff of revolutionaries. ID at 48, 49, Exhibit 16 at 2 to 3 minutes, I guess. In addition to not raising to the level of an agreement, Mr. Cox was clear that no violence should ensue from his arrest or that of Vernon, Barney, or Olson. For sentencing, Mr. Cox's statement on 241 are mitigating. He resisted Olson's entreaties that they should pursue 241 if Cox were arrested. He showed more than reluctance. He showed opposition to violence as a response to his arrest. This is supported by the recordings. The 241 discussion continued after February 12th, often injected into the conversation by Olson, the informant who, like Fulton, kept pressing Cox to come up with a plan. See docket 743-1 at 30 to 32 minutes. I think it means minutes on a recording. Discussions on February 15th and 19th, and on at least 2 occasions, Olson attempted to revisit Cox's view as expressed on February 12th that his arrest or death should only be met with raising hell, short of violence. Docket 743-2 at 50 to 51, Exhibit 2 at 38 to 39, and both times Cox remained firm that his arrest was not a reason to start 241. On February 14th, the topic was raised by Olson. Mr. Olson, what should this is what Mr. Olson said. I guess this is a recording. What should we come up with a game plan of what happens if they get you and they capture you and for some reason they all of a sudden won't release you? That's a quote from J.R. Olson, the $300,000 whore. Yeah, he made a lot of money trapping Cox and also getting off his own Hells Angels arrests. Okay, so Exhibit 42, Government Trial Exhibit 19T at 2 to 3 minutes.
I don't think it's minutes, but anyway.
2 to 3.
Yeah.
Cox consisted with...
Consistent. You want me to read?
No. Cox consistent with his comments 2 days earlier stated, just raise hell. Just TV and newspapers and Gandhi type, just passive-aggressive shenanigans out the wazoo. Just be creative and aggressive just as much as you can without turning bloody. ID period. Olson would not let it go and asks, yeah, and at what point does it get bloody? To which Cox responds, I don't know, man, followed by continued general discussion, ID period. Then on February 19th, the day that Cox and his family were kicked out of the Vernons' home and moved to Coleman Barney's house, Olson diverted a generalized discussion about war versus a fight to 241 with. Mr. Olson said, "What happens when they start grabbing us one by one? You know, if they were to swoop in, say they were to swoop in, take Lonnie, take you guys, charge you with all kinds of federal crimes, you know, you're looking at crimes of 20 years. And I'm left out here, you know, Ken Thiesing and I and a few of these other guys are left out here, and we know our numbers next. You know, it'll just be a matter of time before they come in. Then what? What initiates the 241? He's constantly prodding Cox, is my opinion. Docket 743-3 at 92-93, Exhibit 20 at 22-23. Cox again refuses to say that 241 should begin with any of their arrests and instead gave a vague response about only being valid when the option of allowing that scale to continue slowly tipping in our favor is totally out of the question and not doable. Unquote. ID. The government's foundation for its request for a 26-year sentence is its claim that the trial evidence made it clear that Cox stated that in the event of his or a militia member's capture, that the 241 plan would be put into effect, and in the event he or a member of his family was arrested, emphasizing the existence of the arrest warrant for Cox, that arrest also trigger a violent response. Docket 748 at 13. The only evidentiary or record support it cites for this claim is its Ninth Circuit appellate brief. One has to peel through that characterization of the facts to excerpts of record.
To the excerpts.
To the excerpts of record it cites, and then to the underlying trial documents to determine whether there is anything beyond rhetoric to support its claim. By citing only to its appellate brief, the government distorts the meaning of the events it describes in the appellate brief. Unpeeling this onion reveals that the basis for this foundational fact supporting its sentencing claim is the generalized academic discussion when 241 was first raised on February 12th. These discussions are found in Government Trial Exhibit 15T and Exhibit 2 attached to the defendant's resentencing memorandum. See Docket 743-2 at 13. It ignores the more specific discussions in Cox's objections to 241 as an appropriate response to his arrest as set forth above. It also ignores the statement by Cox made on February 12th. Now, keep in mind, we are all just speculating now. End quote. Docket 743-2 at 32, Exhibit 2 at 20. And its own view of these statements in the email that follow the following day to the U.S. Attorney describing this discussion as generally kicking around ideas. Docket 743-3 at 47, Exhibit 16 at 1. Mr. Cox did not endorse 241 as a response to arrests or incarceration as argued by the government. The only support he expressed for 241 was in the context of a war, and if his children were taken away from him during the course of such a war. In discussing an actual war, something that Cox expressed a desire to avoid, he began by observing, quote, "We might lose our family, some of our wives, children might get killed, so war." Docket 743-3 at 109, Exhibit 20 at 39. Then this theoretical discussion turned to what the response should be if their children were taken away during such a war. It is here that Mr. Cox endorsed a 241 response, ID at 109-10, Exhibit 20 at 39-40, with knowledge of Cox's previous concern about losing his son to OCS. Olson then pressed this hypothetical, by this point far removed from reality, and shifted it from the discussion of war to arrests and OCS. This is what Mr. Olson said. So, okay, now I get back to this, because I want to have this stuff clear in my head. So, if they come, say tonight, just throwing this out there, they show up at your house because somehow they tracked you here with their satellites or whatever. I mean, this sounds crazy, but and they come in, they arrest you, they take Marty for aiding and abetting, and they send your kids off to OCS. Then is it an order to initiate 241? You know what if they come and Mr. Cox said, yeah. Mr. Olson said, take you and your wife. Mr. Cox said, I think so. ID at 111, Exhibit 20 at 41. Olson then emphasized, and your kids are gone too. At which point Cox says, that's an order. When they come for the kids, ID at 111-12, Exhibit 20 at 41-42. This is a fantastical scenario. The only arrest warrant was the state court misdemeanor warrant for Cox. There were no warrants for Barney Marty Cox, and there were no issues with OCS or even a suggestion that OCS might take Cox's children from him in February 2011. The government's reliance on these generalized 241 discussions is similar to what was rejected by the district court in the Huttery militia case. Stone, leader of the group, okay, this is a small paragraph, engages in a conversation with Meeks, Sickles, Piatek, Joshua Stone, and Clow about killing police officers. Stone again brings up the idea of murdering an officer and attacking the funeral procession. Nothing resembling an agreement to spark an uprising with federal government is reached during this conversation. Defendants toss out ideas of ways in which to kill police that are often incredible. More importantly, they never come to a consensus or agreement on ways in which to oppose federal agents by force. Stone even states there's 101 scenarios you can use. This back and forth banter, like the other anti-government speech and statements evincing a desire, even a goal, to kill police, is simply insufficient to sustain the seditious conspiracy charge. It requires an agreement and plan of action, not merely advocacy or hateful speech. Order of acquittal. United States versus Stone, number CR 10-20123, ED Mitch, March 27, 2012, docket 767 at 17. When it came time to sentence David Stone, the leader of this conspiracy, for possession of a machine gun which included relevant conduct concerning 2 other firearms, the court sentenced him to 24 months and 2 days, a term which he had already served, X 43 at 16. David Stone sentencing transcript. The government properly argued that the weapons were inherently dangerous in the context of an anti-government organization that engaged in training with these and other similar weapons, and Mr. Stone was the leader, and as the leader specifically talked about the desire and intent to kill law enforcement officers and their families, and that the weapons were frequently carried in cars in inherently dangerous situations, ID at 9. Like the Huttery case, the 241 discussions were never rose to the level of an agreement, much less a plan. And like Huttery, the possession of illegal weapons along with other weapons along with such discussions is concerning and can fairly be considered in sentencing. But as in Huttery, it is important for the court to distinguish between crimes involving specific plans and agreements to kill in generalized discussions like 241. If the government is abandoning its candid admission at trial that 241 was a roundtable discussion and a debate rather than ever characterizing it as an agreement, docket 647 and 87, it should at least provide the parties and the court with specific record references or other evidence which would support this change of position. Its closing argument characterization of the conversations as a discussion rather than an agreement otherwise appears to be accurate. See docket 743. You don't have to read.
Just say numbers.
Numbers. Okay, good. Cox wanted to get you guys' thoughts on the subject, reminded Olson. Now keep in mind, we are all just speculating now and asked anyway, what are you guys' thoughts on 241? I really wanted your feedback when Barney asked him for clarification on what would trigger 241. He answered, I don't know. That's what we've got to talk about. Oh, gosh. What page am I on?
You're on page 11 of 19.
Backtracking now on 241 distracts from the nature and circumstances of the Stalinist martial law conspiracy on which the Ninth Circuit based its conspiracy liability and avoids much of the defense argument concerning the nature of this offense as upheld by the Ninth Circuit. While the government now characterizes defense reliance on that theory as vacuous, see docket 748 at 4, the defense brief spends a significant amount of time on the Stalinist takeover of the United States and when that may or may not happen. That argument shifts the needle of the issue to the vacuous. It remains the only legal basis supporting the count 12 conspiracy conviction. Number 4. Mr. Cox should not be held responsible for the actions of the Vernons with respect to their separate conspiracy to murder a federal judge and an IRS employee, and his sentence should not be aggravated based on that separate conspiracy. In its original sentencing memorandum, the government observed that Lonnie Vernon was in many ways on his own track with respect to his own actions. Docket 550 at 61. But now it tries to more closely link Mr. Cox to Lonnie Vernon by arguing that if Cox was arrested, Vernon was ready to take up his cause, that Cox's attempted weapons purchase on March 10th was in furtherance of arming Vernon, and that even if Cox was not the one who would ultimately use violence, he was perfectly happy to have others around he could instigate, and that Lonnie Vernon was a prime example. Docket 748, 41328. Do I have to read that little bit?
Yeah, I would say footnote 2 at the bottom of page 11.
In addition to not constituting any kind of an agreement to use violence, as opposed to engage in First Amendment protected activity, the discussions themselves never contemplated, even as a hypothetical murdering anyone if one of the militia members were arrested. To the contrary, the hypothetical discussions involved arresting two people if one militia member was arrested and killing two people if one militia member was killed. Docket
you don't have to
numbers. In fact, the separate conspiracy by the Vernons to murder stands in sharp contrast to the conspiracy in this case. As Mr. Vernon acknowledged in his plea agreement, the Vernons had developed a specific plan and agreement to murder Judge Bistille and IRS Revenue Officer Janice Stowell. He also admitted to having specific plans to carry out that murder, which he shared with J.R. Olson, the government informant, in the days leading to his arrest. United States versus Vernon.
Let me know if you'll...
Numbers. When arrested, he was conducting a weapons purchase with J.R. Olson and Fulton, separate and apart from a later weapons purchase by Cox and Barney with Olson through Fulton. When he was arrested, Mr. Vernon was found to possess a map with post-it notes of Judge Beastline's family's address and the routes to those addresses highlighted, along with numerous letters to family and friends explaining that if they received the letters, the Vernons would no longer be living. ID at 13. The sentencing memorandum filed by Lonnie Vernon makes no mention of Schaeffer Cox, much less any argument that Cox influenced Lonnie Vernon in his decision-making related to Judge Beastline and IRS Revenue Officer Stowell. At Mr. Cox's first sentencing, the government pressed an argument that Mr. Vernon was a loyal foot soldier of Mr. Cox, and the court commented that Vernon was also a follower of Mr. Cox, and I can't help but wonder whether how much Mr. Cox's influence over Mr. Vernon may have lent some impetus to Mr. Vernon's desire to kill a federal judge. Docket 605 at 61. The government was correct that Mr. Vernon was on his own track. Mr. Cox, in fact, attempted to dissuade Mr. Vernon from using violence in retaliation to his separate issues concerning... In relation to his separate issues concerning the foreclosure of his home, and he distanced himself from the Vernons in the 3 weeks leading up to their arrests. It is during this time that the Vernons' planning and actions relating to their separate conspiracy took hold. This is thoroughly documented in numerous recorded conversations between J.R. Olson and the Vernons, conversations and meetings in which Mr. Cox plays no part. These were not offered or played at the trial because they were not relevant to this case. In earlier conversations with Olson and Lonnie Vernon concerning the foreclosure proceedings involving the Vernons' home, it was Olson who fed Vernon's violent comments, while Mr. Cox tried to dissuade or change the subject. And then this is a back and forth. Mr. Cox: I really hope you guys win with paper. Mr. Vernon, inaudible. Up in smoke, inaudible. Mr. Olson: well, the problem is the judge isn't the one showing up out here to inaudible, boost a guy out. Mr. Vernon: there's a headhunt for him that's inaudible. Mr. Olson: yeah. Mr. Vernon: he gets to go hide, inaudible, every day of his life. He'll be looking for that silencer that hits him in the back of the head. Mr. Olson: yeah. Mr. Vernon: that's right, inaudible. Make your bed, you sleep in it. Mr. Olson: well, then it's war declared and, inaudible. Mr. Vernon: it is now. Mr. Olson: it is now, basically with that letter right there, inaudible. The letter they just got today, yeah. Mr. Vernon: declaration of war. Mr. Olson: yeah. Mr. Vernon: yep. Mr. Vernon: uh-huh. Mr. Cox: what about you? They bugging you on anything lately? Numbers, transcript. Then, after further discussion about the paperwork and Olson's taxes, Olson escalates the conversation by bringing up the Randy Weaver case, and Cox steered the conversation toward Weaver's efforts to rebuild his life and his present circumstances rather than the past violent details of the standoff with the FBI. Mr. Olson: yeah, inaudible, yeah, no, I mean, it's war. Mr. Vernon: that's what it's going to be, is war. Mr. Olson: yeah. Mr. Vernon: and the last thing I'm inaudible is it pisses me more to see my little dog shot than anything. Mr. Olson, yeah, oh, and that'll be the first thing they do. Inaudible, them dirty buggers, they'd come beating through your door and they'd take the dogs out right away. Mr. Vernon, that's when they get taken out too. Mr. Olson, look at that. Look at Randy Weaver's phonetic. They knocked his dog out. The first thing they shot, then they went for the kids. Inaudible. Mr. Vernon, for his dog first and the kids. Mr. Olson, yep. Mr. Vernon, that was it. Mr. Olson, yeah, I know it. It's sickening. He's doing good, though. My mom talks to him quite a bit. Inaudible. Yeah. Randy Weaver, yeah. Mr. Cox, where is he now? Mr. Olson, he's in Kalispell.
Wow.
Yeah.
Wait.
I know.
We just learned something incredibly important. We got to find out.
Whose mother?
Yeah.
Yeah. Mr. Vernon, he went to Kalispell. Mr. Olson, yeah, I think this is a long time ago, though. This is like 8 years ago.
Yeah, okay. Yeah.
Yeah, he's living Kalispell, Mr. Vernon, from Nebraska to Kalispell. Mr. Olson, yeah. They went back there for about 3 or 4 years. Then they moved out to Kalispell. The daughters got married, and Mr. Cox lost all his family. Man, what's he doing? Mr. Olson, they live out on a homestead kind of thing, that's 160 acres. They bought 160 acres. They got, which doesn't mean squat, but they got a couple $1,000,000 each, This was consistent with Cox's effort to steer both himself and Vernon away from using a violent response to the loss of their homes or property. Mr. Vernon was involved in sovereign citizen matters and held anti-government beliefs well before he met Cox. His dispute with the IRS that ended up before Judge Bastiline was not part of the conspiracy with which Mr. Cox and Mr. Barney were charged. Cox had a major falling out with Mr. Vernon on February 19th, 3 weeks before the arrests were made on March 10th. At that February 19th meeting, Lonnie Vernon went on a long tirade against Cox about being disrespected by Aaron Bennett at the militia conference earlier that month in Anchorage. Cox's failure to make concrete plans, his irritation with Cox and his family, and Cox's lack of support. Cox unsuccessfully tried to calm Vernon down, but ultimately Vernon kicked him out and his family out of his house, saying,
Just say GD.
Make a GD plan, which you didn't even plan. You didn't even plan to come out to my house. You didn't even bring a GD to go bag or nothing. You have nothing ready to come to my house. And all that I hear from
Effing.
2 days afterward, whine, because we don't have this and we don't have that. I'm sorry, but I'm not putting up with whiny people. I hate whiny people. Get your stuff together. Transcript. And when Cox attempted to respond, Vernon continued the attack and talked about the legal paperwork he and his wife were working on. You sound just like that kid. Your wife's whining like a kid too. I'm tired of that. My wife has got so much paperwork to do right now, it's going to take 8 days minimum to get our stuff in, and I'm not listening to 1 second of that no more. We've got to get this together. The day Cox and his family moved their belongings out of the Vernons' home, Olson maintained contact with each of the co-defendants in the Cox case, but had Cox and Barney on the one track and the Vernons on a separate track. Cox and Barney ordered one set of weapons from Fulton through Olson, while Lonnie Vernon placed a separate order, also from Fulton through Olson. Each set of weapons was delivered at a separate site and a separate time. The court's earlier musings about how much, if any, Cox's actions and words may have influenced Mr. Vernon and lent some impetus to his separate plan is a legitimate matter to consider. However, reaching a conclusion that Cox influenced Mr. Vernon on the specific conspiracy to kill a federal judge is not supported by the record or the evidence before the court, and there is another evidence which would lead one to the opposite conclusion. The defense requires that this separate conspiracy be kept separate and that the defense requests that this separate conspiracy be kept separate and that this unanswered question not be used as a factor in aggravation. Number 5. Are we almost done?
You're at page 16 of 19.
Oh, gee.
You want me to read?
You know what? This is a lot about talking. I can't believe all this.
It's all about words.
It's ridiculous. It's like a word.
Go to prison for 26 years for words.
Yeah.
You want me to read?
It's all about words nowadays. Okay, no, number 5. In the context of Cox's personality and legal case, the web postings cited by the government are not aggravating but mitigating. The government appends as its only exhibits to its sentencing memo various web postings attributed to Cox. Even if these writings are all solely attributed to Cox as opposed to supporters, they show that Cox has shifted his focus from militia activity and preparation for extreme scenarios of societal collapse to working within the legal system on his federal case petitions to the executive branch for redress of grievances and state and federal FOIA requests. This new focus is both protected by the First Amendment and ultimately a pro-social effort to obtain relief through existing government institutions. In many posts, he uses his skill at translating legal writing to popular prose by summarizing the legal arguments in his case. See example, the writ of Audita Carella, docket numbers, his petition for Satori docket numbers, and the Ninth Circuit briefs docket numbers. Like a number of people who are actually trained in the legal profession, he does have some difficulty understanding and explaining the Supreme Court's categorical approach for defining crimes of violence. See docket number, and he or his supporters raise money for FOIA litigation in which Cox does not have appointed counsel. See example docket number. The government's exhibits mostly omit the public comments to his postings, but one example does show how Mr. Cox's internet presence exposes him to cutting criticism from the public. See example docket 748 numbers. In some postings, Mr. Cox expresses dissatisfaction which turns his case has taken. With turns his case is taken. For example, he takes issue with his misdiagnosis with schizophrenia in his original sentencing proceeded and the way it ended up distorting his lived experience.
See docket numbers.
But both psychologists at the BOP and a more thorough evaluation by Dr. Cunningham have now shown that he was right to be dissatisfied with the diagnosis. And although the government may be unhappy about certain claims of innocence and overreach by the prosecution in this case, it is important to remember that Mr. Cox was vindicated in part by the Ninth Circuit vacation of his solicitation conviction. He is innocent of that offense for reasons of self-defense in addition to federal jurisdiction. Ultimately, Mr. Cox's internet postings are consistent with Dr. Cunningham's descriptions of his personality. He seeks attention and exaggerates the facts, but these aspects of Mr. Cox's history and characteristics do not counsel in favor of a higher sentence, but rather a quicker integration back into the real world, where one cannot attract a following simply by portraying oneself as a political prisoner. Number 6. Letters from family members and close acquaintances. In addition to this response to the government's resentencing memorandum, the court is asked to consider the attached letters from family members and close acquaintances, including his former attorney Robert John, who can speak to his interactions with Mr. Cox concerning his dispute with OCS over Cox's son,
Don't say the word.
Seth.
Okay.
Everybody knows. Cox's...
Just say S from now.
Okay. Cox's present views among the sovereign citizen movement and the toll that placement at a CMU has taken on Mr. Cox. Mr. Cox's mother was interviewed by Dr. Cunningham, and much of what she has to share about her son is contained in that report. Her letter focuses on the personal impact the CMU placement has had on her son and the family as a whole. The photographs are submitted to demonstrate that. Mr. Cox has a close and active family that will continue to support him upon his release from prison. Dated this day,
28th day.
the 28th of October 2019, respectfully submitted, Michael Filipovic, Federal Public Defender, and Ann Wagner, Assistant Federal Public Defender, attorneys for Francis Schaeffer Cox. Certificate of Service from Susie Strait. I certify I electronically filed the foregoing message.
You know, I think we always pronounce it Filipovic, but I've been corrected, and I forgot how he really pronounced it. It's Filipovic?
Let me look at it again.
Somebody, anyway, I can't pronounce it.
Filipovic.
No, but it's
Filipovic.
Filipovic. I think it is Filipovic.
Filipovic.
Yes. Anyway, this document will be placed on yearofjubilee.com on Cox's webpage, and you can download it and read it for yourself. We'll also post it on Facebook. Thank you to my wonderful wife who read 19 pages with no breaks.